Good morning, everybody. Thank you so much for having us here today, and I appreciate Cynthia's introduction. I am an attorney with Procino-Wells and Woodland. Just to give you a little bit of background about us, we have 3 attorneys in our office. I'm licensed in Maryland and Delaware. Michelle Procino-Wells and Amber Woodland are also licensed in Delaware. We have 3 locations at this time. We have our newest location in Berlin, Maryland, right on Williams Street. And then our original location is in Seaford, Delaware. And we have a 3rd office in Lewis, Delaware at the Village at 5 Points. We're a little bit unique as elder law attorneys. We consider ourselves to be a boutique law firm. So what I mean by that is we only do very concentrated areas of practice. Okay? So when we say we're elder law attorneys, that means that we focus our practice on areas that affect our aging population. In addition to the 3 attorneys, we have 13 team members within our office. So 3 attorneys sounds like a small firm, but when you look at us as a whole, we're a pretty big team. And everybody has a pretty specialized role within the team. Okay? So the very first thing I wanted to do, I'm going to try to walk around. If I don't do well with that, I'll come back to the podium. But yeah, okay. So when I say we're elder law attorneys, is that too loud? Okay. When I say we're elder law attorneys, I think it's really important to specify what it is that we're talking about. So we're an area of legal practice that emphasizes on those issues related to our growing aging population. And when I narrow down our practice areas, what that means is that we focus on really 5 categories. So estate planning is certainly an element of our practice, estate and trust administration, guardianship for disabled adults, and then asset protection planning and applying for and obtaining eligibility for government long-term care benefits. We're going to focus this presentation on the last 2 bullet points on that slide and really sort of dig deep into some of those things that might be impacting you, might be impacting your neighbors, loved ones, things like that. So the reason that we're going to have this conversation is because we want to talk about long-term care, getting assistance with long-term care. And why is it that we want to talk about the legal and financial elements of planning for long-term care? The answer to that is the cost. Okay, so we have some information up here. We get this from a Genworth survey every year. The most recent information came out in 2017, and it's specific to the Salisbury area in Maryland. So for in-home care, Genworth estimates that for 44 hours per week, so not 24 hours per day, but 44 hours of care at home per week, the average cost of care is about $4,212. Okay, and that's per month. For assisted living care, the average cost of care is just over $6,000 per month. And then for skilled nursing care, the average cost of care is about $127,750 per year. So that's just over $10,000 per month. So the reason we're looking at getting assistance for long-term care is because if you or the person who needs the care doesn't have sufficient income to cover this expense, you need to consider other options to pay for the care that's needed. So let's consider our payment options, okay? Medicare is different than Medicaid, okay? Medicare is something that you qualify for when you reach age 65, and it's something that provides general health insurance. In addition, you can buy supplemental health insurance policies that pay supplemental to the basic coverage, okay? When we're talking about long-term care, we're talking about care sometimes in a facility setting. So sometimes individuals will transfer to a skilled nursing facility for rehabilitative care after, say, a medical stay or a hospital stay of some kind. Medicare can pay up to a maximum of 100 days if certain requirements are met to get there, okay? So Medicare provides some skilled nursing level of care, but it's decidedly short-term. It's not long-term, okay? Other ways to pay for long-term care might include long-term care insurance, And if you don't have long-term care insurance, then you may be in a situation where any amount that your income doesn't cover, you have to look to your lifetime savings and liquidate things as needed in order to pay any of that deficiency to the care provider. Additionally, there are two public benefit programs that we look to primarily, and that is long-term care Medicaid, and then VA aid and attendance pension, which are two public benefit programs decidedly available to pay for long-term care. And we're going to walk through those things today. Before I get into how to qualify for these public benefits, I want to first explain how they work, okay? If I am to apply and become eligible for long-term care Medicaid, once it works, once I'm eligible, my monthly income, my net monthly income, will be contributed to my cost of care, okay? That's called my patient pay responsibility. I'm allowed to keep some things, like I can continue to pay my Medicare deduction or my Medicare supplemental insurance policies. I can continue to keep a $78 personal needs allowance, but everything else of my income is going to be contributed to my cost of care, okay? However, anything that my income doesn't cover, Medicaid covers the balance, okay? So if, for instance, my net monthly income is $2,000 per month, but my cost of care is $10,000 per month, I've in essence received a benefit of about $8,000 per month once I'm qualified for long-term care Medicaid, okay? VA aid and attendance pension is different, okay? VA aid and attendance pension is a way of getting a supplemental stream of income into the household for either the veteran or the surviving spouse of a veteran. And it's a steady stream of income. It's a fixed amount, and we're going to talk about that. But the purpose of the VA aid and attendance pension is to provide a stream of income that covers unreimbursed medical expenses, okay? So it's not covering a full benefit or a whole shortfall or monthly deficiency, but it is a stream of income that can help offset some of those costs. So Medicaid has a three-part eligibility test. I will tell you, there's the medical test, the income test, and the asset and resource test. I live in the world of the financial aspects of the test, okay? The medical facility or the skilled nursing facility where the applicant is receiving care is really doing the medical assessment. They're determining whether that patient requires assistance with activities of daily living such that they meet that eligibility test, okay? Important in the state of Maryland for long-term care Medicaid, when we talked about those three levels of care, so community-based care, assisted living care, and then skilled nursing care, long-term care Medicaid in Maryland is most easily accessible at the skilled nursing level of care, so the highest level of care. If you're in an assisted living facility or if the patient is receiving caregiving services at home, Medicaid may not be an available resource. Okay, so that's something to keep in the back of your mind. To satisfy the income test in the state of Maryland, essentially the applicant has to have less monthly income than the cost of care, okay? That's a pretty easy test for most of us to satisfy because we don't earn $10,000 to $11,000 per month to cover that cost of care at the skilled nursing facility. And I'm just going to give a little caveat here. I'm licensed in Maryland and Delaware. I'm focusing this presentation on Maryland. If you have a Delaware-specific question, we can talk about those things too. But the rules are slightly different between states, so I just want you to keep that in the back of your mind if you happen to be from Delaware or have a friend in Delaware. The married income rules and all of the rules actually for a single person versus a married person for qualifying for Medicaid are different. Okay? Medicaid has something called the spousal impoverishment rules. It sounds really terrible, but it's a really good thing. The rules are there really to protect the well spouse or the spouse who stays at home in the community so that they don't become so impoverished because their spouse applied for public benefits that they in turn become reliant on public benefits themselves. okay? And so that's why we have single rules and then we have married rules. For a married applicant, the applicant's income will be contributed as their patient pay responsibility to the skilled nursing facility. But the well spouse, or the spouse who's at home, is able to keep unlimited amounts of income. They have no obligation to contribute their monthly income toward the cost of care of the applicant spouse, okay? If we have the spouse who stays at home and their income is very low, we may be entitled to get a contribution from the applicant spouse to the well spouse before their patient pay calculation is determined, okay? We call that the MIMNA. It's just fun to say. The minimum monthly maintenance needs allowance, okay? So if I have a well spouse who's staying at home and she has below $2,000 in monthly income, then what we'll try to do is get a bump up for her, contribution from the applicant spouse, somewhere between that range, it is a range, before that patient pay is calculated. So the applicant might have their Medicare deductions taken out, they have their personal needs allowance that can be taken out, the MIMNA will be taken out and contributed towards the community spouse, and then whatever the balance is their contribution to the skilled nursing facility. On the asset and resource side of things, people often ask, what's income versus what's resources? Think of income as regular payments that come in. It might be monthly, might be quarterly, might be annually. That's considered income under the rules. Things that are fixed in value, right? They might change in value, but they're more fixed assets, like your house, your IRA account, your checking accounts, and things of that nature. They're considered to be resources under the Medicaid regulations, okay? So when we're doing or applying the resource test, the very first thing that we're doing in our office is we're determining what is a countable resource and what is an excluded resource. So excluded resources are those resources that Medicaid says you can keep and it doesn't count against you. Otherwise, assets are considered countable if they are available or accessible or you have authority over those assets, okay? Unlike the income test, in a married couple context, anything that is available to one spouse is attributable to both spouses, okay? So what's his is his, what's hers is his, what's theirs is his. Does that make sense? Okay. So the very first thing we do is we look at excluded resources. So some things are excluded just by definition in the regulations. So vehicles, one for each spouse, can be excluded. Household goods and personal effects. Life insurance that has no cash value. Prepaid irrevocable funeral arrangements are also excluded. Income producing real property is unique to Maryland, and there's some nuances there, but it can be a really good item if you've documented it to exclude that resource. And then the residence of any value, so long as the well spouse continues to reside there, okay? So I said this before, but available resources or countable resources are anything else that either the applicant or if they're married, their spouse has authority over, the power to liquidate, the power to exhaust, anything at all, okay? For a single person, the rule is that their countable resources cannot exceed $2,500. For a married couple, the general rule is that the married spouse can keep 50% of the remaining countable resources, but there's a minimum of about $24,000 and a maximum of just over $123,000, okay? So if when we do that 50-50 split, it would cause the well spouse to have more than $123,600, the maximum they can keep is $123,600, okay? I want to talk to you about the Lookback Rule. The Lookback Rule is something that we hear people come in and talk about to us often, or we're in a workshop setting or something like that, and people will talk about the 5-year look-back period with respect to Medicaid. The reason I want to talk about it is because I find that it's something that's commonly misunderstood. So I think we should just clarify this if we learn nothing else today, okay? The 5-year look-back rule is meant to say that when you apply for long-term care Medicaid, essentially there's an inquiry on the application that says, have you transferred assets and received less than adequate consideration in return within the last 5 years, okay? So what the application is asking is, have you made a gift within the last 5 years? Because if you have, we're going to penalize you because we're going to assume that you made that gift so that you could intentionally qualify for Medicaid assistance, okay? The way that the penalty works, we call it a look-back period because it starts on the date of application and it looks back 5 years, okay? So if there were any transfers within that 5-year period, then that's something that needs to be disclosed to Medicaid. Once that information is disclosed to Medicaid, what you'll disclose is the value of the gift, when it was made, and then the Medicaid worker will do an analysis, okay? They're going to take the value of the gift, divide it by a number called a penalty divisor, okay? The penalty divisor is meant to represent the daily rate of care in a skilled nursing facility. So essentially what they're calculating is how many days of care could you have privately paid for if you had retained that gift rather than gifted it away. The way that the penalty works is that on the date of application, if you're otherwise eligible, Medicaid will assess what that penalty period is by number of days or months, and they will say, although you're otherwise eligible today for the benefit, we're not actually going to contribute to your care until that period of days or months expires. So if you've not been strategic, or you've divested yourself of an asset and you can't get it back, you can get yourself in a really sticky situation where you're not eligible for the benefit, or you're eligible but they're not paying the benefit, and you don't have an alternate way to pay for your care. So you need to be really careful and strategic if you're going to make gifts, and there's a possibility you might need care within 5 years. There are some penalties that are exempt. We actually have a transmittal in Maryland that excludes certain types of gifts like regular tithing, gifts that are made in hardship situations. So there are some presumptions in our favor as an applicant that we can look to as support to say this gift didn't count, okay? Also, there are unlimited transfers permitted between spouses to a blind or disabled child, but you have to be careful making transfers to blind or disabled child who might need public benefits themselves. And then there's also an exception under the Medicaid regulations that talks about making a gift of the primary residence to an adult child, caregiver child, who provided caregiving services for a period of at least 2 years that essentially kept the applicant from needing skilled nursing care during that 2-year period, okay? So those are just some of the exceptions that are recognized under the regulations. I'm going to switch gears here and talk about veterans benefits, if that's okay. So when we talk about veterans benefits, I will tell you there's a whole host of veterans benefits that are out there, and I only know about a small portion of those veterans benefits, okay? Because I am looking at veterans benefits as a potential payer source for a veteran or their surviving spouse's long-term care needs. So most commonly, when we're looking at public benefits for a veteran, we're looking at the aid and attendance pension benefit, okay? It's a service pension benefit, so it's a way of getting a stream of income into the household, remember, to pay for unreimbursed medical expenses. Just to give you an idea of the actual benefit that we're applying for, here are the numbers. Okay? So if I have a single veteran who's applying for VA aid and attendance pension, the maximum monthly pension is $1,830. If I have a married veteran who has a dependent and their spouse would be considered a dependent, they can receive up to $2,169. If I have a surviving spouse of a veteran, they can receive up to $1,176. Sorry, they change these numbers every so often, so I have to look at them, okay? So that's what we're applying for, getting this additional stream of income into the household. There are 3 parts to the Veterans Benefit Test, okay? There is a military test or a service requirement. There is a medical test, and then the financial test is also assessing income, and then resources or net worth is how they refer to it. So on the military side of things, the veteran has to be a person who is active in the military for at least 90 days of a continuous period of time, and at least one of those days had to occur during a declared period of war, okay? It doesn't mean that the veteran needed boots on the ground necessarily, and I oftentimes get the question, Vietnam was considered a conflict, was it really a war? Congress has defined the Korean conflict and the Vietnam conflict as a declared period of war. The way we assess this is we actually take the DD-214, which gives us the dates, right? Gives us the discharge status, and as long as it was anything but dishonorable, they can be eligible for the benefit. And we compare that with our chart that has our time period for the declared period of war. And so if that service requirement is satisfied, then the veteran or the surviving spouse of the veteran has satisfied that element of the test. The active duty period is 90 days, continuous period, and at least one of those days has to be during a declared period of war. Okay, so the medical test, right, for veterans benefits, I will tell you the best advantage for veterans benefits is when my client is receiving care at home or in assisted living, okay? If they're in a skilled nursing facility, Medicaid is by far the best benefit. But if they're in assisted living or they're at home and I can't get Medicaid to assist them with their cost of care, the veterans benefit can work wonders in keeping someone aging in place for as long as possible, okay? But to satisfy the medical test, I have to have a medical professional sign off on an affidavit. It's actually a physician's affidavit that is signed, and it essentially says that the claimant or the applicant needs assistance with at least 2 activities of daily living, okay? So activities of daily living, that's probably something that there's some familiarity with, but bathing, dressing, feeding, toileting, transferring, those are all considered activities of daily living. So that's what we're looking to. So there's a financial test, just like for Medicaid eligibility. Of course, the rules are different. So sometimes we're applying for veterans benefits, but then we're kind of looking ahead to say, well, what would happen if skilled nursing care might be needed in the future? How do we qualify for VA now and not disrupt potential eligibility for Medicaid in the future? So it can get a little complicated. But the income rules for VA, essentially, VA is saying if you take all the household unreimbursed medical expenses compared to all the household income, if the medical expenses exceed that income, you have a negative income for VA purposes. We call that the IVAP, okay? So if you have a negative IVAP, you can satisfy the income test for VA aid and attendance pension. The financial test, continuing on, this is sort of the resource or the asset test. So we've looked at income, now we're gonna look at everything else. The VA is not black and white like Medicaid is. VA is a little more gray. So for a single claimant or applicant, we want their net worth to be somewhere between $10,000 and $30,000, okay? Because what we're trying to establish to the VA is that this person doesn't have enough net worth to otherwise pay for their care, even if they have a negative income for VA purposes, okay? For a married veteran, they can keep between $50,000 and $80,000. And this is all a matter of counseling our clients through what they're sort of tolerant of. A lot of times we're working with the CPA and the financial advisor to sort of vet some of this information out. But that's the requirement. There are certain assets that are excluded for VA purposes. Some of those are similar or the same as the Medicaid test. So prepaid funeral, the home can be excluded, the vehicles, the personal possessions. Those are all things that can be excluded both for VA and for Medicaid. Currently, the VA has no look-back period, okay? So technically speaking, you could transfer all of your assets the day before applying for VA, and you could immediately satisfy the financial eligibility test for VA. I would not recommend that, okay? Mainly for the reason I just talked about. Sometimes we're applying for VA to help us age in place, but we always have to be aware of what might be around the corner. And if skilled nursing care is needed in the future, the $1,100 per month that you got for mom under the VA is not going to cut it when she gets to the skilled nursing facility. So you might still have those penalty rules to think about if and when you get to Medicaid within 5 years. Okay, so now we're going to try to, now that you have a familiarity with the benefits, I want to give you some background and information about planning to look to those benefits as potential payer sources if and when long-term care is needed. Generally speaking, when we have clients who come in, we're trying to decide whether they should proactively plan, whether they're at some intermediate stage, or whether there's a crisis right now and we need to apply for benefits as soon as possible. This pyramid is meant to give you some visual about the extent of the protection that we can offer at various stages of planning, okay? So at the base of the pyramid, if I have a client who anticipates that they have more than 5 years to plan with, they might engage in some proactive planning now and protect a portion of their assets and then continue to enjoy their other assets until and unless they ever need skilled nursing care, at which case they might do some intermediate planning or they might engage in crisis planning, okay? Those who do pre-planning, the portion of the assets that they proactively plan with will be 100% off the table as long as the plan is appropriate. Okay, the 100% off the table for Medicaid eligibility purposes. At the intermediate stage of planning, that's where we would sort of have a discussion with a client who maybe has a diagnosis or has started to experience some difficulties, and they think, you know, I can manage things right now, or we're doing pretty well right now, but we might need assistance, and we don't think it's going to be more than 5 years before we need that assistance. So we might engage in some intermediate planning strategies at that point. Crisis is usually where clients are in a skilled nursing facility or receiving long-term care in an assisted living facility, and we're saying, how do we get you qualified for either VA or Medicaid as soon as possible to protect as much as we possibly can? A lot of times our pre-planning occurs in the context of our estate planning, right? So when we're assessing what are your objectives, who are the people, what are the assets, what are your concerns, we will engage in a conversation about pre-planning at that stage, because at that stage, if you're a healthy senior, that's the time to have those conversations. I get this question. I have a slide at the end about ethics, but I'm going to talk about it a little bit now. I think it's important to understand why we do the planning that we do. I am traditionally an estate planning attorney, which means for years I helped clients minimize their tax exposure, and I still do that on a regular basis. But I get people sometimes who ask, is it ethical to plan to rely upon public benefits at some point in the future if I need long-term care? And I will tell you, I sleep very well at night. I don't think planning for long-term care is that much different than planning to minimize your taxes. Okay? I haven't met a single client yet who says, I want to pay as much tax as I possibly can. And I haven't met a single client yet who says, I want to pay as much as I possibly can on my long-term care, okay? But the reason I sleep well at night is because I know my why. And my why is I want to make sure that there is a payment source available for services that are needed. I can't tell you how many caregivers I've met who have been running themselves ragged because they think, I can't afford care. I can't afford care. I don't want to eat tuna fish every night because I can't afford care, okay? The planning that we do ensures that there's a payment source available for care that is needed. The second element of the planning that we do is we do work to preserve a nest egg, okay? When we preserve a nest egg, what we're doing is we're setting aside some of the client's resources so that when they qualify for Medicaid or VA, and they're otherwise destitute to satisfy that eligibility requirements, their family or their trusted people in their lives have this nest egg that they can use to supplement the public benefits that they're getting. So if they need new clothing that Medicaid's not going to pay for, the kids can use mom's money to pay for the clothes that she needs at that stage of life so that she can continue to live a dignified life throughout her lifetime. And then for some clients, they are looking to provide a legacy. They don't want every penny that they own, that they've saved their whole life, to go to pay for their care. They want something to go on to their children or their grandchildren or their favorite charity. So I'm going to talk to you about an asset protection trust first. So this is a tool that we use primarily in our pre-planning side of the practice. Okay? So I have a healthy senior who's coming to see me thinking ahead about long-term care. They may or may not have long-term care insurance, but they decide at some point I want to set aside a portion of my nest egg. I want to engage in this 5-year plan to protect some of my assets. I oftentimes, forgive me for this, but I picture trusts as buckets, okay? So picture a bucket that has a lid on top of it, and it has a spout or a spigot off to the side, okay? In order for the asset protection trust to do what it's supposed to do, which is to make the asset unavailable to you for Medicaid purposes, be a completed gift at the time of transfer, it has to satisfy these requirements, okay? So when we're drafting the asset protection trust, it's going to be irrevocable, meaning you can't change it if you just change your mind 2 years from now, okay? It is designed to own some of the assets, never, ever all of the assets, okay? And what you decide to put into the trust is a matter of counseling and conversation, and it often involves many of your sort of professional team to help you make those decisions, okay? The assets in the trust are protected once they're transferred in, and at least 5 years then passes before you apply for benefits. And that's to satisfy that 5-year look-back rule, remember? So what are the limitations then? What does that lid represent? That lid represents that the client who creates the trust cannot be the trustee, cannot be the manager of the assets inside of the trust. But the client can select anyone in the world that they want to act as the trustee. It also means that the client who sets up the trust will not have access to the income or the principal from the trust, okay? Why is that? Because if you had access to the income or the principal, then when you apply for Medicaid, Medicaid would say, access the income and principal and pay for your care and see us when you're down to $2,500, okay? However, the client who sets up the trust can select anyone in the world that they want to serve as lifetime beneficiaries of the trust. So those are the person or people that the trustee, when the time comes, can distribute income and principal to, okay? Those individuals then can do whatever they want with those funds. I will tell you, in most of these situations, if it's an adult child who's serving as trustee and it's adult children who are listed as lifetime beneficiaries, the trustee is making distributions out of the trust to the lifetime beneficiaries if and when those lifetime beneficiaries want to purchase those new clothing, right, for mom when she's otherwise destitute and qualified for Medicaid. That's the spigot or the spout off to the side, okay? There are also the ability within the trust to identify death beneficiaries. And so there, the trust functions much like a traditional will would function. At my death, everything in equal shares to my kids or everything to the Alzheimer's Association, whatever the case may be, okay? So this trust provides long-term care protection if Medicaid or VA is ever needed in the future. It avoids, assets inside of the trust avoid probate, and there can be direction as to where the assets go at death, okay? While the trust is intended to be a complete gift for Medicaid purposes when the transfer occurs into the trust, we designed the trust to be an incomplete gift for tax purposes because we want the client who's established the trust to continue to receive all the tax benefits and burdens associated with the assets inside of the trust, okay? So people will ask me, well, why would I transfer assets into a trust? Why don't I just make a gift of my house to my children? And actually, I missed a very important part. I can also retain for the client the right to reside in real property contained in the trust, whether it's the initial residence that's placed inside of the trust, or it's a residence that the trustee has purchased later down the line. So there's the ability to downsize or whatever the case may be, and no one can ever kick the client out of their own home, okay? So getting back to that point, why wouldn't I just make an outright gift to my kids? And the answer to that question is there's a lot of benefits that the Asset Protection Trust can provide that an outright transfer can't provide. Number one, the Asset Protection Trust insulates those assets from the lifetime beneficiaries and the trustees, creditors, right? Divorces, bankruptcies, personal injury actions, whatever. The other is that tax issue, right? We get all those tax benefits, which are somewhat complicated to understand in a setting like this, but one of the major benefits is if the house stays a house, right, and it doesn't pass on to the kids until my death, they're going to get a step up in basis just like they would if I had transferred it at my death in my will, rather than an outright gift where they inherit essentially my initial basis in the property. So there are tax advantages and creditor protections to using the Asset Protection Trust. Intermediate planning, I will tell you, is really the area that we're looking at here. Is we know we have less than 5 years. So what we're trying to do is we're looking to the family and determining what are their circumstances, what's going on within the family, what are some appropriate solutions to get mom, dad, brother, sister, spouse, whatever caregiving services they need, and how can we look to the Medicaid regulations to allow us to essentially make transfers in this 5-year period that aren't going to count against us when we go to apply for benefits within 5 years, okay? So sometimes what we're doing is we're creating caregiver agreements where the elderly parent is maybe paying the adult child for performing services that an outside person might have to provide. In that context, usually it's the first time that that adult child or that elderly parent ever thinks about compensating anybody for their time, but it's a way of there being consideration in that exchange rather than an outright gift or transfer. The Medicaid regulations allow the applicant to purchase a life estate interest in the home of another as long as they purchase it for fair market value and they live there for at least 1 year before applying for benefits. We talked about the caregiver child exception before with respect to the primary residence, so that's sometimes something that we're looking to in that intermediate stage. And then also paying for improvements in the home of an adult child, right, if the elderly parent moves into the home of the adult child. I will say for all these things, you have to make sure you document these things on the front end. It's not something you can document just before you apply for benefits, So if any of these things sound like they might be helpful to your situation or a friend's situation, you need to meet with an elder law attorney to help navigate and document those things ahead of time. Crisis planning, right, is that planning that we do at the very last second. I might have somebody who's getting ready to transition into skilled nursing care. I might have somebody who's been there for 5 years and they still have assets left. They're still over-resourced. In fact, we had this happen in our office not too long ago. A gentleman had been receiving skilled nursing care for 10 years and paid privately for 10 years, but he still had about $200,000 left by the time they got to us, and we were able to protect about half of that $200,000 at the very last second. So my point is, it's never really too late. So in a crisis context, essentially what we're doing is we're taking the countable pot of resources, and we call it spend down, which people hate, but that's the term that Medicaid uses. We're spending down those countable resources on things that are excluded, right? So we're just shifting them from one pot into another so that they no longer count against the applicant. So some of those things include the funeral arrangements, purchasing burial spaces and markers both for the applicant, their spouse, other family members. That's always an interesting point in the conversation. You can buy your kids burial plots, their spouses burial plots, whatever. New vehicle purchases are sometimes an appropriate expenditure. Home improvements. Paying off or paying down debt is always a natural given as far as spend down goes. Taxes, right? Sometimes we're liquidating assets and there are taxes involved as we liquidate those things, so the taxes should be paid as part of the spend down. Professional fees, sometimes we're hiring a CPA to do some analysis, an attorney to do some spend down for us, so those things are all appropriate use of the spend down funds. And then occasionally it makes sense to purchase income producing real property, okay? But these are all crisis scenarios. See, these are last-minute things that can be done to protect assets. They're not necessarily something that everybody should go out and do right now. If we have countable resources after we have appropriately spent some of the money on excluded resources, the question becomes, well, how do I get qualified if I still have money? Okay? And this is where we might use a Medicaid compliant annuity in order to achieve immediate eligibility for Medicaid. A Medicaid compliant annuity is something very specific, and it's something that's defined very specifically under the Medicaid regulations. Forget everything you think you know about an annuity, because most of us think about an annuity as an investment vehicle. This annuity is a protection vehicle, okay? So to qualify, the annuity must be a single premium immediate annuity. It must be irrevocable and non-assignable. And then how we use the annuity will differ depending on if we have a single applicant or a married applicant. So I'm going to talk about the married scenario first, okay? For a married spouse, let's say after doing the analysis of what's excluded, what's countable, and then we spend some of the money on additional excluded resources, and there's still a pot of cash left over for the community spouse. Say they're over-resourced by $100,000, so they have $223,600 to their name. In that situation, we can take the $100,000, we can invest it in the Medicaid compliant annuity, and the spouse will immediately be eligible for long-term care Medicaid. The way the annuity works is that we've taken this $100,000 and we've instead converted it into a true annuity, which is just a monthly stream of income back to the well spouse. To the well spouse, because she can keep unlimited amounts of income and she's not required to contribute that to her husband's care, okay? So that annuity will pay out, for the term of the annuity, we have to use a term that is no longer than her life expectancy. Okay, so it could be shorter, but it can't be longer. And as that annuity is paid back out over time, she can use those funds however she needs to, right? If she lost $4,000 in monthly income because he applied to skilled nursing care and that's going to the facility, Now she can use this annuity to help satisfy her household expenses. Or if she has some that she can save each month, she can continue to go back and reinvest those funds for her future planning. Okay? In a single context, it's a little bit different. So in the single context, we're using the Medicaid compliant annuity to provide a payer source during a planned penalty period. Okay? So let's say the single person, after we do appropriate spend down, has $100,000 in resources. Roughly half of that value, $50,000, will be gifted the day before we apply for benefits. Okay? It might be gifted to an asset protection trust, it might be gifted to an adult child, but it's gifted and it is disclosed to Medicaid. And so Medicaid will then take the $50,000 transfer and determine the penalty period based on the $50,000. And they will determine that that $50,000 transfer rendered a, let's say, 3-month penalty period. Okay? So Dad is otherwise eligible today, but the benefits aren't going to kick in for 3 months. Remember, I do this because I want to make sure people get paid for the services that they need, right? The other $50,000 that we didn't give, we invested into the Medicaid compliant annuity, which has a term that is exactly as long as the determined penalty period for Medicaid. So it will pay out exactly what Dad needs every single month in conjunction with his other income, that his skilled nursing care will be satisfied every month during that 3-month penalty. At the end of the 3-month penalty, the annuity is gone, and Medicaid then picks up, right? He contributes his income, Medicaid essentially covers the difference. But we've got Rose here. She's the client, she's the applicant for benefits, and she is now looking to transition into skilled nursing care. She currently has a residence, checking account, money market account, brokerage account. She has an IRA, and she has a vehicle. She has one adult child, Diana, and she's added Diana to some of these accounts for convenience purposes, right, so that Diana can do her bill paying for her or whatever. We don't recommend that, by the way, but that's the way they come into the office. So even though Diana's name is on the account, it's Rose's money, and Medicaid will treat it as Rose's money. So if we look, she has total resources of about $350,000. And so the first thing we do is we look at what's excluded versus what's countable. So the excluded resource is the $5,000 car. Everything else is countable. So she has $345,000 in countable resources. So maybe Diana is the power of attorney, and she's the one who's working with us to say, I don't know what to do to get Mom eligible, but I don't see this money lasting her very long in the skilled nursing context. So we talk about spend down to become immediately eligible for long-term care Medicaid. So Diana helps her mom do her prepaid funeral. She trades in her $5,000 vehicle for something that's a little more suitable. Maybe it has the ability to use a wheelchair or something like that so that Diana can use that to help her see her children, her grandchildren, things like that. When we liquidated that IRA, right, in order to accomplish spend down, we had tax consequences, so we've attributed $30,000 towards the taxes. She had maybe a credit card debt of $5,000, and then she's paid the nursing home also along the way. So any private pay will be part of that spend down. So after she engages in that spend down, she still has $252,000 worth of countable resources, okay? So here's where we're going to engage in that gift and annuity strategy to get her immediately eligible. So we take the total assets and we subtract out her resource amount that she's permitted to keep. So we put it just under the $2,500 just to be safe, so we're never over that $2,500 mark. So that brings the net asset value to $249,600. Her monthly cost of care is $11,000 per month, and she receives income, maybe it's her Social Security, of $1,700 per month. The penalty period divisor on a monthly basis is $8,684, okay? The penalty period will begin on her otherwise eligible date. Okay, so you don't get the benefit of the penalty running until you actually apply for and are otherwise eligible for Medicaid. So then we calculate it out, right? I have a program that I used, and so that's why I'm not just saying 50%. We actually ran these numbers. So the gift amount here is $129,848.56, and the annuity amount, the amount that's invested in the annuity, will be about $119,751. The $129,000 figure divided by the penalty divisor is what gives us a 13-month penalty period, okay? So for 13 months, that annuity is structured to pay Rose exactly what she needs, right? $9,378, which will be contributed to her care at the skilled nursing facility, along with her monthly income, so that she never goes without services and the facility never goes without payment throughout that entire penalty period. Now, this is important information, too, at the end. When we set up these annuities, Rose is the annuitant, or the owner of the annuity, okay? To be Medicaid compliant, she has to name the state of Maryland in the first position as a beneficiary on the annuity. She can name anybody she wants as a contingent beneficiary. The reason the state of Maryland has to be identified as the primary beneficiary is essentially the state opens up a tab when you apply for Medicaid benefits to track how much they're spending for your care. And at the end of your life, they're entitled to recover that against any estate that you might have, okay? So to be Medicaid compliant, they have to be in the first position, because if you die before the annuity's up and they're entitled to payment, they want that payment. But remember, this annuity is running during the penalty period, right? So if it ends early, is the state of Maryland paid anything? No. So the benefit, God bless you, will actually go to her contingent beneficiary. Okay. So I'm not going to, there's a couple of slides that are left up here. There's some Medicaid myths, things that we hear in our office often, that I just think we've sort of debunked throughout this conversation. You are not alone in this. A lot of times this is the first and only time you're going through this really difficult experience, and the Alzheimer's Association website is a great starting point to start to get that support. So thank you all for your attention.